Okay, we're on the record in Graves versus May. This is case number 2110999. If I could have both counsel put your appearances on, please.
Good morning, Your Honor. William Carey appearing on behalf of the plaintiffs, all three of whom attend this hearing today with me.
Thank you.
Good morning. Kevin O'Neill on behalf of Robert May, who's to my left.
Okay, thank you. We're on the record here today for purposes of an evidentiary hearing. Mr. Carey, your clients are alleging that Mr. May has not complied with the judgment that was entered previous in this case. Is that correct?
Yes, sir, that is correct.
Okay. And Mr. O'Neill, is your client contesting that?
Yes, Your Honor.
Okay. All right. So, Mr. Carey, was there anything that you wanted to present by way of any kind of opening before we get started?
I'll be brief in opening comment is simply a note what the record in your file already does, that it was a little more than a year ago today when final judgment was entered in this matter. Final judgment was entered after a contested trial on whether or not Mr. May had any property interests in the subdivision, including the roads of the subdivision, of Scotts Lodge subdivision. And as part of that final judgment, the court also conditionally awarded costs and attorney fees to the prevailing party, to the plaintiffs, and subsequently a motion for the entry of an order for costs and attorney fees was heard by the court. In the time frame that has passed since the entry of the judgment, my clients have noted, are prepared to testify, to offer documentary evidence in the form of photographs that Mr. May continues to utilize Island Street, continues to, advertise is the right word, continues to use a street address of Island Street, allows by invitation or otherwise contractors servicing his property to use Island Street, as proofs would show if we need proofs, actually filed a complaint with the Crawford County Sheriff's Department that my clients blocked his access to Island Street, called the Sheriff's Department complaining that he was being physically blocked from being using Island Street. And I remember when the court entered its opinion on the record, and I didn't agree with it then, but I have reflected since and understand that the court's rationale that we should start with essentially a declaration of rights. Mr. May, here's a judgment that says you cannot use Island Street. So Mr. Carey and plaintiffs, let's not have an injunction now that everybody knows how they're supposed to behave. Maybe an injunction won't be necessary, except for the fact that the last year has proven that an injunction is necessary to give the plaintiffs a valid and legitimate remedy should Mr. May continue essentially to ignore the order of this court. So we are here and intend to present proofs unless Mr. May would acknowledge his violations, that he continues to use Island Street in violation of the court order. We'll ask for an injunction to preclude that use in the future going forward. We are going to ask that he be sanctioned for the need for us to seek that injunction. And then we are asking the court to revisit the issue of the previous order of sanctions and attorney fees and provide a number for us to reduce to a taxable judgment based on the prior order of the court.
Okay, and just to address that last point, I did look through the file and the court did enter an order in December of last year addressing that issue. So there is an order in the file for a payment of a specific amount based on the motion that we had.
I don't.
Yeah, neither one of us received it.
Okay. And that may be you know, the court's fault. But there was, let's see. The last thing before you filed this motion in the file was December 15th of last year, the court entered an order for payment of $3,194.87.
All right, well, that resolves that issue then.
So, yeah.
I did not. Yeah. Okay.
And
so
it does, Jennifer, my assistant, did file a proof of service that it was mailed on the 16th to both parties. So
something went wrong there.
Something went wrong in the process.
If one of us didn't get it, then we could probably take the heat for it, but neither one of us got it.
Right.
So that's correct.
So that I think does take care of that issue at least.
It does.
Okay.
Thank you. Thank you for that was a prompt turnaround from my request of a minute ago.
Right. Well, and when I saw that as part of the motion, it concerned me because number one, I don't want to have things that I'm supposed to do out there for a year not being done. So, and I didn't remember not having done that. So I'm glad that we have that cleared up. Mr. O'Neill, was there anything that you wanted to present?
Let me see. Typically too, when I'm waiting on a decision, we generally would go 5 years. I'm waiting on a federal court decision now from 22. And a lot of times say, well, don't bug the judge. Just don't bug the judge. We also do that. Your Honor, we were here for a matter, I think it would have been late September, early October of 2022. You did issue a final judgment. One thing I did as a mistake on my own behalf, this being a property matter, I did not view the property until after. We got done with this situation with the court. The court made its decisions. And Bob said to me, you want to come out and see my property? So it's about 15 miles east of here. So I went to it. It's not a gated community. It's their property. It's their, the court says we're not to go on Island Lake, but it's a 2-track. It's nothing formal, nothing fancy. It's nice wooded lot property is what it is. And since then, Bob has been staying off that property line. He has not been going on the property, on the street or in their Scottsdale division. What Bob's been doing and what I saw that day was he was maybe 50% back in when I went in October of 2022, 50% of finishing his home. And that's what he was having done. And he has been, you have, as you know, when you put a home, when you put a log cabin on, when you're getting water and anything else, you have to have permits to do that. And we can show to the court, we can show to counsel, he has drawn up a map that he hands out to everybody and specifies to the people that come to put a permit to come to get on his land to use the proper road that we all agree he can use, McMaster, and not to go on to Island Street. And in this instance, my understanding is really what there's a 1-day violation here. And all the man was trying to do was to have electricity put into his property. And in this instance, and he can testify if you need, or you can just hear what both of us are saying, is he calls the power company and says, I need electricity. And they come out to look and he says, by the way, you're not supposed to go on Island. You're supposed to go around and use McMaster. And they say, well, we got our own utility easements that we can use. They flag the area. And 40 days goes before all these photos that show you the photos of the truck that comes there. and they flag it. And so then he prepares the area. It's just a straight shot just to go, instead of him having to go all the way around and come back. And the power company comes out and is going to put the power, and these gentlemen meet them, and within like 15, 20 minutes say, you gotta leave. You can't give this man electricity. And that's all he was trying to do. And he was relying on them saying that they could do it. When the power company backed off and said, we can't put it on, he's kind of waited for today for me. I don't know whether we have to make a motion to allow that in this one instance or whether the court will entertain that. That's all he wants to do. And the ground wasn't hurt. Nothing was hurt. It's just, I just don't understand why we're here over such a petty thing is what we're doing. He didn't go. He didn't say, come on through here. He can explain about the separate driveway if he has to. He's been granted that address by the county. He didn't come and look for that address, but he can explain what's called a 911 access, and maybe the court understands those themselves as to, I think, an alternative method to get off the property if it has to be done in an emergency. So that's first way. That's all this is about. I mean, I think the court has more valuable time to do than this. Trying to lay electricity in a line that the power company believes. If we stop power companies from going and doing their job, that they can't give a man electricity or water on his property, I just think that's wrong. And I think this is a court of equity, and I think a court can look through all that. We don't have 365 days of him coming and running up and down that street and doing whatever he wants. That's not this case, and that this is just wrong. Thank you.
Okay. All right. Mr. Carey, I mean, are we dealing with more than one alleged violation here?
Yes.
We are. Okay. All right. Well, I think then we're gonna, if we've got that much of a factual dispute, then I think we will need to take some testimony. So, and I'll obviously give both sides an opportunity to do that. Mr. Carey, your first witness, please then.
Stand and have to be sworn in.
You can raise your right hand. Do you solemnly swear or affirm that the testimony about to give today shall be the truth, the whole truth, and nothing but the truth? So help you God.
Thank you. And sir, if you can just state your first and last name for the record, please.
Robert Weed, W-E-E-D.
Thank you. Proceed when you're ready, Mr. Carey.
Thank you. Robert, would I have your permission to call you Bob?
Absolutely.
Bob, where do you live?
10431 Island Street, Grayling,
What subdivision is your property located in?
the Scotts Lodge subdivision.
All right. And you've been a plaintiff in this case since its inception?
Yes, I am.
And in a brief way, can you tell me what you and Mr. Graves and Mr. Warner expected and want to accomplish by way of this litigation?
Certainly, our biggest issue really was the driveway that was initially built accessing Island Street. Again, the issue, at least in my mind, wasn't so much that we had a problem with Mr. May, but in my experience with real estate, subsequent owners can be a problem. If you were to sell it to someone, the property could be subdivided, and if that driveway off of Island Street has existed long enough, it means everyone who has a subdivided piece of that property now is allowed to access that property off of Island Street, which means extra traffic on our road, extra wear on our road, extra maintenance that we're responsible for. And that really was our issue, in that it was property that should have come off of McMaster's, since that's where it faced. And all we were looking for was for, as Mr. May did, to develop a driveway off of McMaster's to access the property, and subsequently to change the address to McMaster's Bridge Road as opposed to Island Street, so that subsequent contractors would not come pulling onto Island Street to that location in order to try and gain access to his property.
Gotcha. You heard it described earlier in council statements that Island Street is a two-track. Is that, at least in your opinion, an accurate description of Island Street?
I would say it's a little better developed than just a two-track. Yeah, there is no grassy area in the middle. We plow it in the wintertime. We have people that will grade it, take gravel and repair potholes. There is a fair amount of maintenance that goes on with it because we have full-time residents up there, as well as a number of people that come up seasonally. And it takes some effort to maintain the road in good shape.
Now, prior to the litigation commencing, the physical access to Mr. May's property was a driveway constructed whereby one would enter the May property from Island Street. Is that correct?
Yes.
After the litigation was concluded, Mr. May did in fact put in a driveway from the public road known as McMaster's Bridge Road.
Yes, he did.
After the litigation was concluded, was the driveway from Island Street closed?
It has a chained gate on Mr. May's property. But other than that, it has not been closed, no.
Is the chain gate is on a post and hook?
Yes,
And so anyone wanting to use the driveway off of Island Street simply takes the chain off the hook and goes through.
I would guess so, yes.
All right. What is there all of our properties require, as counsel noted, a 911 street address. You understand that?
Yes, I do.
In Grayling, as I understand it, or Crawford County, as I understand it, those addresses are by assigned numbers and the signs are a green background with white lettering.
That's my understanding.
After the litigation was concluded and the court ordered Mr. May not to use Island Street, did Mr. May remove his street address from the junction of the objectionable driveway and Island Street?
No, it's still there.
It remains there to this day.
Yes.
Does Mr. May have, to your knowledge at least, an address sign, an entryway sign that directs people to use his driveway located off of McMaster's Bridge Road?
I'm not familiar with any, no.
Okay. I'm going to give you a package of photographs. Court has a package, council has a package. We're going to go through them and hopefully everybody's package is in the same order. I should have, Your Honor, and I didn't. So I'll take some direction from the court. I should have had these stickered as exhibits. I wonder if we should do that now or after the fact.
I think if you want to mark them all as just one exhibit, and then we can, like exhibit A, and then we can number the pictures individually under one exhibit.
All right.
So we'll call this plaintiff's exhibit A. And then as you go through them, you can just, we'll do them just in numbered order.
Great. I'm not, because I'm intending to use my package as the package of photos that will be exhibits. I'm not going to put any kind of writing on mine, if that's all right.
Okay.
Bob, do you recognize what's shown in exhibit A1?
I do.
What is that?
It's a sign that had been placed on some oak trees on some of the Scott subdivision property. The reason it was placed there is we had noticed that someone had placed red tape around them, kind of an indication that they were supposed to be prepared for cutting. And the tape was removed, and we subsequently placed a sign on the trees indicating that they were not to be cut down unless authorized by someone from Scott subdivision.
This next photograph, A2, do you recognize what's shown in that photograph?
It appears to be the same sign, just from a little bit further back on Henry Street.
And is in A2, is Henry Street shown in the background beyond the sign?
Actually, that would be Island Street that's shown in the background behind the sign.
Okay, so are the trees at issue on the south side of Henry?
Actually, they'd be on the west side of Henry.
The west side of Henry.
Yeah, towards the southwest intersection with Island Street.
I see. All right. And Henry is not shown in that photograph, but Island Street is.
Correct.
Okay. With respect to those trees, these photographs look like they were taken at least in the early fall. What's the status of those trees today?
They're still in the same place.
How come, if you know, they didn't get cut down?
Apparently, they had been marked for Great Lakes Energy to cut them down and remove them in order to put up another pole to put electric access into Mr. May's property.
And that has not happened?
No, it has not.
Do you know why it hasn't happened?
The only reason I know is that when Great Lakes Energy came out to do the installation, we informed them that those trees were on subdivision property, and we preferred that they not be cut down. We did not want them removed. And at that point, after showing them the injunction, basically saying that we had the right to not let someone remove the trees. The Great Lakes Energy supervisor packed up his crew and ceased work, and subsequently about 45 minutes later departed.
Do you personally, as a subdivision, as an owner within Scotts Lodge subdivision, have any opposition to Mr. May enjoying the benefit of electricity on his property?
Not at all. He's built what looks to be a very nice cabin on the property. He built at least from the vantage point from McMaster's Bridge Road, what appears to be a well-constructed and very nice driveway for access into his property. He seems to maintain it very well. I don't have any problem with having electricity installed on his
Are
property.
utility lines in existence on McMaster's Bridge Road?
They are.
And is it your position that to enjoy electricity and other utilities, if there are any, Mr. May should utilize the services from McMaster's Bridge Road that is adjacent to his property?
Well, there is electricity on McMaster's Bridge Road. There is also a Great Lakes Energy utility pole on Mr. May's property on the west side of Henry Street.
Gotcha.
So we feel there is ample access for electricity to his property. We don't have a problem with him getting electricity.
Is there any other way to access Henry Street beyond driving down Island Street to where it meets Henry?
Yes, you can come in on, I believe it starts out being called DG Inman Way and turns into North Fork Road. But there is a similar street that comes in from the north that accesses to Henry.
I got you. Okay. Go to I'm sorry, where I got that. A3, that's our third photograph in the package.
Yes.
What, do you recognize what is depicted in that photo?
Yes.
what are we looking at and what is its relevance to this proceeding?
It's a post for the gate that Mr. May had for, at one time, access to Island Street.
Gotcha. Is that a post that hosts the chain that you made reference to earlier?
Yes, there's a subsequent post that the chain attaches to off to the side,
I gotcha.
to its left. You can kind of see the sign at the very edge of the photo.
All right, now if you would move to A4. Do you recognize what's shown in that photograph?
I do.
Can you-
That is I'll get a post with the chain across it at Mr. May's property with the green and white address sign next to it.
And what road is that sign, that green and white sign, and the post shown in A4 adjacent to?
Island Street.
Island Street. We're not talking about anything coming off McMaster's Bridge Road.
No, this photo was had to have been taken from Island Street.
Gotcha. And does that sign, street sign, does that post and does that chain, all shown in A4, remain there at that location yet today?
It does.
Okay. A5. What am I looking at when I look at A5, if you know?
Yeah, it is the roof of one of the Great Lakes energy trucks that's parked on Island Street in front of the aforementioned gate that we were just discussing. And the photo is facing Mr. May's property in the background.
And the driveway that I'm looking at in A5 that shows a post, a wooden post on the left-hand side, is that the driveway that comes from Mr. May's home or cottage onto Island Street?
Yes, it is.
Not onto Henry Street, not onto McMaster's Bridge Road, but onto Island Street.
That's correct.
And how, I noticed at the bottom of A5 that this photograph appears to have been taken by what I would call a trail cam.
That's a very accurate description.
Accurate in the sense that, yes, indeed, this picture was taken by a trail cam, or am I describing the device accurately as a trail cam?
It was taken by what I would call a trail cam, yes.
All right. So was there do you know about a trail cam installed on Scott's Lodge subdivision property, looking in the direction of the May Island Street driveway?
Yes, yes, it happened to be my trail cam, and I helped install it.
All right. And was the trail cam set up so that it accurately reflects the date of September 25th, 2023?
Yes, it was.
All right. Now, when you had the issue regarding the potential removal of the oak trees on that was on Henry Street, not Island Street, is that right?
Yes, you're right.
And in the Great Lakes energy truck that appears in A5, that's at a different time and in a different location than this issue dealing with the threatened removal of trees on Henry Street?
It was the same time of day. It's just a different location.
I got you. Okay.
Same date?
Yes, same date.
Okay,
Yes.
thank you.
Yeah, I guess date, that was probably an important
Well,
distinction.
yeah,
Yeah.
I didn't know if you meant at the same time of day.
Yeah, I appreciate that. Yeah, thank you. next photo, which I'm hoping is A6. Is A6 depict the same information as A5 generally?
Yes, it does.
Likewise, A7.
Yes. The truck apparently is just moving.
I don't know what you mean by that.
Well, the truck has changed position in those photos.
I got
So
you.
obviously the work truck for Great Lakes Energy has moved,
Gotcha.
but the everything else with the trail cam has remained the same.
A8.
And I don't want to short circuit things, but I mean, just looking through there, there's.
I'm gonna try to short circuit.
29
this if I can.
photographs, it looks like between 9:48 and
Yeah,
10:36.
yeah,
from the
I'm
same
gonna, if,
location.
I didn't know if the court would let me, but and if council would let me, but I would like to do the two sets of photographs in kind of in a one broad brushstroke.
I don't have a problem with just admitting all these photos that go to approximately 10. The last one. Just, I think we're all smart enough to understand what it is. So
Yeah, I agree.
1022 maybe is the last one of those.
I see 10:36.
Let me go one more. I do see that one. I have no objections.
Okay, why don't we do this? Let's get, switching things up. Let's do A1 through 4, and then let's just treat all of those photos as one exhibit B. Do you have an objection to that, Mr. Carey?
A1 through 4 is
A1 through
A.
4 would be the pictures of the trees, the gate, and the address.
1, 2, 4,
And
and
then,
it's starting with the truck. I
right,
didn't just speak over it.
yeah, exhibit B would be all of the trail cam photos.
Okay.
Starting with 9:48 AM and ending with 10:36.
Understood.
Any objection to that?
No.
Okay.
What I don't know that was set forth for the record is in the group marked B. Do we know? Did you count?
There are 29.
29.
Yes,
So that would be B1 through B29.
correct.
Okay. Are you following along with us, Bob?
I am. Yep.
All right, I'm happy that you are. Bob, with respect to the exhibits B1 through 29 taken by your trail cam, do you know why the employees of Great Lakes Energy were at the junction of Island Street and Mr. May's old driveway for such a lengthy period of time? Were they performing work at that location?
No, they had started to begin work on the property and were preparing to cut the trees. When we had the conversation with them about not cutting the trees, they reassembled all of the equipment, pardon me, at that location in front of where the address sign is, and just spent some time there discussing things among themselves. I wasn't privileged to hear what their conversations were. They didn't share any of that with us.
Even if you had been privileged, we wouldn't share them here today in any event. Did Great Lakes Energy move equipment onto Mr. May's property?
They did,
From what location?
from Island Street.
From Island Street, not from Henry Street.
Right.
Okay. And I assume, but I will ask, from Island Street on what I would like to call the old May driveway.
They accessed it that way and drove around the chain gate to get access to Mr. May's property.
And they did that at a time when Mr. May was advertising that driveway as his address through that green and white sign.
The green and white sign was up at that time, yes.
All right. So let me show, can you see this from here? This is a photo I want to ask you
Yes.
about. Are you at that point?
Yep.
I don't know. Was that from the previous A? Or is
Nope.
that after these?
This is after B.
May have it else. Well, this is the last one I had. Oh, let me take a look, please. Was there other trees that?
You have that.
Yes.
Continue.
Okay, thank you.
That's not it.
That's okay. Picture, I should see it from there.
All right. I'll share with you.
Not necessary.
Robert, what am I looking at
Oh,
in
okay.
C?
This is a view from Henry Street, looking at what I would describe as a backhoe, a Great Lakes Energy backhoe on Mr. May's property.
Is that backhoe part of the equipment that you described as being placed on Mr. May's property from Island Street?
Yes, this picture was taken by one of my neighbors with his phone camera in the same time frame as the other photos that we have been discussing in Exhibit A.
All right. And the last two photos depicting what I'm sorry, last three photos are all photos of the Great Lakes Energy trucks
Yes.
prior to them not cutting the trees down and leaving.
Yes, that's correct. All three of those were taken of Great Lakes Energy equipment on Henry Street.
On Henry Street.
Yes, on Henry Street.
So they had moved from Island Street down to Henry Street.
They had moved that equipment down, yes. It was preparatory to cutting the trees down.
Gotcha. Your Honor and Counsel, do we want to call these last three C2, 3, and 4, or do we want to give them a separate?
Yeah, we'll do the last, all four of those, C 1 through 4.
Very good. Do you recognize what's shown in this drawing?
Before we do that, can you just show counsel that?
Yeah, I was actually just want to make sure he recognized it first before I did, but either way, I don't care.
Yeah, I just want to make sure, well, before he comments on any.
Absolutely.
Mr. O'Neill can see it, okay.
Try to follow along. What is generally depicted in this drawing?
It's a hand-drawn plat map showing Highland Street, Henry Street, lots in the Scott's Lodge subdivision and Mr. May's property.
All right. Would you place with an ink pen a number 1 at the location of the 911 address sign that Mr. May continues to maintain at Island Street?
Sure. Would you like it numbered with a little circle around it?
That'd be great.
Fine.
And better than that, I'd like you to put your very small initial next to that number 1. All right. Would you also, with a number 2, in the same manner, place the location of your trail cam that has been testified to?
Put these on for a second.
Yeah, I gotta do the same thing.
Where's the other spot I didn't catch?
1
Okay,
and 2.
thank you.
Move for E.
Any objection?
No objection.
Okay, we'll take E. E, oh, I'm sorry, we're on D. Thank you.
See the value in pre-marking exhibits? You mentioned a trail cam.
I did.
Did you bring the trail cam today?
Yes, sir, I did.
All right, so let's talk about the trail cam a little bit. Is it fair to say that the purpose of the trail cam was to attempt to capture the use of Island Street by Mr. May or his guests or invitees?
Yes, that would be correct.
All right. And for a period of time, was the trail cam producing photographs?
Yes,
Indeed, we have gone through many of those photographs.
correct.
Did there come a point in time when the trail cam no longer functioned?
There did.
Did you ascertain why the trail cam ceased functioning?
I did. It was up high where we needed a ladder to access it. So we checked it every couple of months to pull the memory card out and see what pictures were available on it. Around the end of October, one of my neighbors and I went up the ladder, and the first comment was, "Looks like it's all covered with mud." We pulled the game camera down and determined that it had been, in my expert opinion, shot with something. My best guess is a paintball gun. It was splattered with things. The infrared generator was broken. The camera was no longer functioning. And when we took the memory card out, the last set of pictures that it had been able to take before being broken was October 6th.
And anything that you could comment on in regard to the use of Mr. May's property on or about that date of October 6th?
Well, the only thing I know for certain that was a Friday when Mr. May had guests up to his property. There were a number of trucks and jeeps that were up there.
Gotcha. But to be clear and not to leave any unwanted inferences, you did not see anyone shoot the trail cam with a paintball gun, correct?
That's correct. Yeah, we did.
Nor did you see.
I did not see any identifiable indications that any person did it, or have no proof from what direction it was done. That's absolutely correct.
Nor did you see anyone on Mr. May's property on or about that date sporting, carrying a paintball gun.
That's also correct. There was absolutely no evidence of that on Mr. May's property.
We struggle with these Ziploc bags. You brought that trail cam to court with you today.
Yes, that's the one you have in your hand.
Is it in the same condition it was when you removed it from the tree?
It is. I took the batteries out because I wanted to test the batteries to make sure that the batteries were not dead. All the batteries were still functioning. It was just the trail camera that wasn't functioning, and then it was put into the plastic bag, and it's been in there ever since.
And I assume you removed the SIM card?
I did, yes.
All right. Also, this is the trail cam that you installed and then subsequently took down per your testimony.
Yes, that's correct.
And within the flash area of this game cam are pieces of that portion of the game cam that presumably were broke by the splattering of the paintball.
Yes.
Move for the admission of the game.
Any objections?
No objections.
Okay, we'll say that's exhibit E.
Um,
I'll just make it.
Yeah.
You're not gonna get it.
No.
Okay.
Yeah. I'm almost done with Bob. Bob, have you, since the entry of this judgment, this final judgment in October of last year, have you observed a vehicle parked between Island Street and the chained off old driveway of Mr. May?
Yes, there was one occasion, I believe it was in May of this year, when a dark blue pickup truck had come in off of Island Street and was parked in that area facing the chain gate of Mr. May's property.
Did you observed personally, not by someone telling you, that blue pickup truck?
Correct.
At the time you observed the blue pickup truck, was it occupied?
No,
Was anyone, at least based on your observation, walking about the subdivision, Scotts Lodge subdivision?
I did not see anyone.
Were you able to ascertain, at least circumstantially, by tire tracks, for instance, or other means, how the blue truck was able to come to a parked position at that location?
Well, it appeared obvious to me that it had come in off of Island Street and parked there. But we had looked around the neighborhood. There was nothing out of sorts. There didn't appear to be anything that generated concern. So it was duly noted, but no follow-up was done with it beyond that.
I got you. Do you know for what period of time the truck was parked there?
Oh, I don't. My best guess would be maybe an hour.
Okay, all right. I don't have additional questions of this witness.
Thank you. Mr. O'Neill?
Thank you. Sir, concerning the trail cam that's been put in as exhibit, when was that put up first?
Oh, it was first put up early this year, in the spring, probably.
Spring of 23, you're saying?
Yes.
Did it replace one that was there previous?
No, it did not.
Okay, and so you put it up in the spring of 2023, and it sounded like sometime, the last pictures that noted was October 6th, but you took it down subsequent to October 6th?
We took it down towards the end of October. That's correct.
Okay, end of October. And were there, and from my understanding, this camera looks at the one driveway off of Island Street that goes into Mr. May's. That's where you position it to look. Is that correct?
Yes, you're correct.
Okay. So it was there for whatever period of time that is. Did you have other trail cams up and down Island Street?
No, we did
This
not.
was the only one? Okay. And I would think if you put a trail cam up there, you probably looked at it on a regular basis.
Yes. you're
How
correct.
long would you say you looked?
You mean how often?
How often?
we download it? I would say probably about once every 4 to 6 weeks.
Once every 4 to 6 weeks. Was the intention to see if Mr. May was coming off of his property and going onto Island Street using the driveway?
And that or the other way around. We were
Okay,
just
yeah.
curious as to whether or not the driveway was being used. That's correct.
I haven't heard you. And would you have been, every time it was viewed, were you one of the people that viewed it?
Yes.
Okay. I didn't hear any testimony during that period of time of you seeing Mr. May going to or from his property using that there was no pictures of on the camera.
That's correct. There's no evidence that Mr. May himself ever used that driveway to go on to Island Street.
Okay.
That's correct.
His wife,
There is no evidence of Mr. May, his wife, or
anyone?
anyone that we would consider his family. The blue pickup truck was the only
The
occasion.
only thing is the blue pickup truck.
And the Great Lakes Energy, of course.
Okay. Okay, and how about, I mean, we were here. Oh, boy, I think I remember you were one of the gentlemen that was here last September of 2022 when we were in court with the.
Actually, I was not.
You were not? Oh, okay. Well, can I ask you, before the camera was put up in September, in the spring of 2023, did you see Mr. May or his family using that driveway?
Do you mean
I'll
after the trial?
Yes.
No, I did not.
Okay. Did you see him on Island Lake Road? Is it called that? Island Road itself? Did you see him himself? No, it wasn't caught on the camera. Did you see him using the road?
Oh, no, not after the trial date, no.
Or his family?
Or his family, correct.
And I thought counsel asked you, you said there's a latch and a gate, a chain across.
There is a chain across.
You've never seen anybody take the chain down and drive through that gate, have you?
No, I have not.
Okay. You said that, and the pictures that we have here are about an event on September 26th. Pictures of the
Yes,
gas
I
truck,
believe-
power company
that's
truck?
correct.
Okay. And did you see,
September 25th, yeah.
was the power truck there at any other dates?
There had been a Great Lakes Energy truck, pickup truck, that had been there maybe a month or two before that. It was one individual.
Okay.
I happened to be out at the time, and it was of course, to me, everyone's younger. It was a younger gentleman that was walking along Island and Henry Street and making notes about the power lines.
Okay.
And I just asked him who he was. He identified himself as a Great Lakes Energy employee, and that was good enough for me.
Didn't tell them to stay away or anything like that?
Absolutely not. No.
Now, when they came out on September 26th, how long was the crew there?
I would guess for a couple of hours.
Now, did you see Mr. May on that day at the property?
No.
The trucks were there. Did you see his wife there?
No.
Any of his family members there?
No.
Okay. And how long would you say that they were there?
A couple of hours.
A couple hours, good. And you and were you one of the group that told them they had to leave?
Well, we didn't tell them they had to leave.
What'd you
We
tell
told them they were not allowed to cut the trees.
Okay, only
It
couldn't cut
was,
the tree.
it was
Okay.
their decision to leave.
I'm trying, did you get you tell me, was the idea that if they couldn't cut the trees, they couldn't continue on the work they wrote on the work they were gonna perform?
Well, our position was they weren't to cut the trees.
Oh, they weren't to cut the trees.
Yeah.
Did you mind if they well, you have an objection to them laying a power line under Island Road to Mr. May's house?
I would have concerns about them repairing it correctly if they put a line underneath, but I really am not knowledgeable about what rights the power company has as far as their easements. I know there are certain laws and easements that power companies get because they're public utilities I'm not conversant in knowledgeable.
Your only objection was that these trees were going to be harmed.
Correct. We didn't want the trees cut down.
How many trees did you think were red taped or in some manner indicating that they were going to be cut?
3.
3 oak trees, it looks like to me, maybe.
They were oak trees, yes. Living oak trees.
3 trees that are going to be cut. Okay, when you said they couldn't cut the trees, it sounds like within that couple hours they left.
That's correct.
Okay, was there any damage to the ground?
No.
Was there any damage in any manner to the to your property or to your subdivision?
No, we don't feel that Great Lakes Energy did any damage to the property at all.
Did Mr. May damage your property at all? No. Okay. Since you told I think it was called Great Lakes, that they had to leave, have they been out to perform any further action on bringing property to Mr. May's house?
I don't know if they have been out. If they have been, I have not seen them. Great Lakes Energy has been out on Island and Henry subsequent to that time. Again, their indication to us was they were doing an inventory of the status of the power poles and the power lines. But they didn't share an awful lot, and we didn't question them strongly about their presence. It's a public utility. We're more than happy to have them come out and keep things in good shape.
And you said on the you said you saw a blue truck, pickup truck. You can't identify who the pickup truck
No,
was.
I don't know who the driver was or the purpose of the.
Was there a couple hours?
It wasn't a couple of hours. I would guess an hour at most.
Oh, I'm sorry. Your Honor, I have nothing further. Thank you.
Any redirect?
Leave to continue direct. I left some photographs off to the side.
Sure.
Thank you. That I don't have copies of, so I think judge prefers it this way.
Kind of. Oh, in order. Which way do I go on that one?
Well, that's a good question, because I think that's the about the time the paintball hit the camera. But I'm trying to give them to you in the order that I'm going to.
Oh,
present
okay.
them to you.
Oh, so I got them backwards now, probably.
Probably, but I'll fix it.
I'll let you fix it.
All right. Do you?
This is back on.
Yeah, good idea. Do you recognize what's depicted in the photograph that I'm showing to you?
I do. This was a picture from the trail cam. Unfortunately, when
And you recognize what's shown in the photo.
Oh, absolutely.
And counsel, you've seen this.
Yeah, but it is helpful to everybody if I don't, like he just did, so I know which you're at. What?
Yeah, for sure.
Straight.
All right. Where are we at in letters?
F.
This would be F.
Yes.
Move for the entry of exhibit F.
No objection.
Okay.
Please describe what I'm looking at in exhibit F.
Certainly. It's a picture that was taken from the trail cam. It's a copy that I made from the digital file at Walgreens, which unfortunately this time cut off the bottom with the date stamp on that the trail cam provides, but I did write on the back. It was taken on October 6th at 6:09 p.m. It again is facing that gate where the green and white address sign is on Mr. May's property.
Gotcha. And apparently at a time when the trail cam was still functioning.
Yes, trail cam was
And
functional.
what am I looking at? Give me a little more of a description of what I'm looking at in the photo. First of all, in the immediate foreground of the photo, it looks like I'm looking at a road, a base of a road.
Yes.
What is that?
That is Island Street in the foreground.
And then midground, if that's really a term, it looks like I'm looking at the old May driveway.
That's correct. The old main driveway and the two posts that had the chain across them.
And indeed, the driveway is occupied by a vehicle, is it not?
There is a red pickup truck there with a trailer behind it. They were trailering a Jeep.
All right, and it is located immediately upon the May driveway, is it not?
Yes.
All right. With a trailer on the back of the pickup truck,
Correct.
right?
Yes, that's what I see it. Yeah.
And on the trailer that's attached to the pickup truck, there is a Jeep.
Yes.
All right. Now, you don't know whether that pickup truck came down the driveway off of McMaster's Bridge Road or backed into the driveway off of Island Street, do you?
No, I don't know for certain how it accessed the property.
But if that truck were to want to leave the May property with a trailer that is occupied by a full-size Jeep, what direction is it pointed in?
Well, it's pointed towards Island Street.
Okay. I'm sorry.
G, and can I have that first one so I can mark it? This way we don't get them confused. Thank you. So yes, we're on G, if you want to keep.
I do. I didn't know if you wanted me to keep going.
Yes, please. Thank you.
Which photo will that be, sir?
This will be G.
Okay,
It's kind of a black and white of this, I think, the same scenario.
okay.
I think, but we'll find out. This is proposed exhibit G. Do you recognize that which is shown in proposed exhibit G?
I do. This
Move
is-
for the entry of exhibit G.
No objection.
Okay, we'll admit G.
Is G essentially depict for us that which you described in F, exhibit F?
Yes, it does.
All right. If you could,
It was, again, taken from my trail cam on October 6th. The time on this one was 6:18 PM. Apparently, it is getting dark enough that the trail camera can no longer generate color photographs. Once you lose light, it can only do black and white.
all right, so that was you're anticipating my questions, but that's okay. With that model of trail cam, it functions both in daylight and in darkness, correct?
Correct,
If it's functioning properly.
correct.
The difference being that once we hit a certain level of darkness, the photographs become black and white as opposed to color.
That is correct.
All right. Go ahead if you want to.
Thank you. And go ahead with the next one.
So this one would be H.
Okay, thank you.
Do you recognize that which is depicted in exhibit H?
I do. This is another one of the photos that was downloaded that I downloaded from my trail cam. Again, October 6th, 6:37 PM.
All right. Then move for its admission.
Not yet.
Move for its admission.
So the pictures pretty well speak for themselves.
Agreed.
I'll stipulate that these came off the trail cam on October 6th that night. We can just fast forward it so the court can have it as exhibits.
Yeah.
I think any testimonies can be just something all three of us can see on our own.
Sure. Okay.
Go ahead.
So we'll admit H, I, and J.
I'm probably not going to do J,
Okay.
but
so
I'm going
H
to do
and
I. And believe me, I does not speak for itself. So
So then.
exhibit
No, it
I.
doesn't speak. I don't know what.
Well, we think we're going to find out.
Okay.
What are we looking at in exhibit I and why are we looking at it? Witness.
This was the last digital image that the camera took before it stopped functioning. Again, October 6th, 8:52 PM. There's nothing really discernible in it, considering the fact of what the trail cam looks like. I'm guessing that something happened to it at right around 8:52 PM on October 6th that caused it to stop functioning.
Gotcha. All right, very good. So we, thank you for granting leave, Your Honor. One question on redirect, which is this. You testified earlier in my examination and also in counsel's cross about a yellow chain that it goes across the old May driveway. Yes? And you said that you hadn't seen Mr. May or his wife and perhaps others using Island Street to access the old May driveway, correct?
That's correct. I have not seen any of them use it.
Have you observed the chain in a down position?
I have, yes, there have been occasions when the chain was down on the ground rather than across to the other post.
And then subsequently put back up?
Oh, yes, and put back on the post.
Okay. If you're comfortable making an estimate of the times you have seen the chain down and then back up, please make that estimate for me. If you are not comfortable, tell me you're not comfortable doing that.
Oh, it could be characterized as a couple, but I'm not sure my memory is good enough to give you an exact number.
That's fair. More than once.
More than once, yes.
All right. And more than once since the court entered judgment in October of 2022.
Yes, it would have been this year, 2023.
Gotcha. All right. Thank you, Judge.
Any cross on
Yes,
these
Gary.
exhibits?
Just probably very brief.
Okay.
The last line of questioning about you seeing the chain down. Were you headed down on purpose to see if there was any activity there? The chain was down or up? Was that the main focus?
It would have been me walking to the mailbox, driving out to go to the grocery store, perhaps driving out to go to the dump and recycling center. It would have been normal travel up and down the road. It wouldn't have been going specifically to look.
But as part of going to do all those functions, you would make sure you would turn to see if it
It's
was
very visible from the road, yes.
Okay, and again, you said how many times you think you saw?
A couple.
Couple, and how many times you think you would have gone by?
Probably hundreds.
Probably hundreds. Nothing further.
Okay. Quick question on the trail cam. I mean, is it motion activated? Is that what causes it to take a picture?
Yes, it's motion activated.
Okay. Thank you. Mr. Carey, any follow-up to that question?
No, sir.
Mr. O'Neill, any follow-up to
No,
that?
thank you.
Okay, thank you, sir. You can step down.
Thank you.
Mr. Carey, any further witnesses?
One additional witness. It's a single topic witness and I expect he will be short in duration.
Okay,
Would you like me to go behind the door?
who do we have?
We have Mr. Larry Warner.
Mr. Warner, if you'll come forward, please.
You can do it right hand for me. Do you solemnly swear or affirm that the testimony you're about to give today should be the truth, the whole truth, and nothing but the truth of the matter?
And you've been identified, but Mr. Warner, for the record, you can just state your name, please.
Lawrence Warner,
Thank you. Go ahead, Mr. Carey.
Mr. Warner, where do you live?
10389 Highland Street.
Island Street. Your address is right off of Island Street
Yes, correct.
in Scotts Lodge.
Yes.
Did there come a time while at or about your residence in Scotts Lodge subdivision during 2023 when contact was initiated with you by a Crawford County Sheriff's Department deputy?
Yes.
Would you explain narratively, if the court and counsel would permit, the circumstances that occurred with that contact?
June 24th, 23. I was in the yard and two sheriff cars came pulling down a neighbor's driveway next to me. And I thought, great, we got some neighbors. because the cabin's not used much, but ended up being the sheriff's. And they asked if I was aware of a property dispute. And I says, yes, I am. So I stated my name to them, and they were called by Mr. May earlier in the day. And he complained that someone had put a stump and a log in front of his existing driveway there that we've been talking about today.
But what I've characterized for my own benefit as the old May driveway off of Island Street, correct?
Yes.
Okay,
Placed that in front of his gate. I can't remember if there was a wire gate there at the time, or if it was just a log. He had, for a number of months, Mr. May had just a tree log laying across.
before the yellow chain.
Yeah, before I don't even know it's yellow, but it's a cable type.
All right.
With a lock on it. It also has a sign on it with one of those intimidating signs that has a gun on it. We shoot.
Take a couple steps back there.
All right.
You lost me,
Okay.
and this is new information to me. There's a sign that you characterize at least as intimidating. First of all, tell me where the sign is.
It's hanging on the cable.
On the cable
On the cable.
that is across the old May driveway. And in your opinion, the intimidating nature or communication the sign makes is that it has a gun pointed at, has a gun in it?
It says something like, we shoot, we don't ask questions, or something like that.
Gotcha. Okay. In any event, you're talking to, let's get back on track. It's my fault, but let's get back on track. You have contact with Crawford County Sheriff's deputies. Mr. May apparently has called them to complain that someone has placed a stump and in a log, presumably blocking use of the old May driveway from Island Street.
Correct.
All fair?
Yes.
What did you say to the policeman?
Well, at the time I said, we put those logs in the stump there, myself and two other neighbors, to get them to stop using the old driveway. And I explained to the Sheriff Lang, I believe his name was. Yes, Sheriff Lang, that there was an injunction that was decided earlier on last year that Mr. May was not to use Island Street or Henry Street. And that's why we put the debris there. And he asked me if I had a copy of the injunction. I said, yes, I do. And he said, I also have an email, which I sent him the file by email.
Him being the sheriff's deputy,
Sheriff, yes.
Deputy Lang?
Yes. So he reviewed that and called me back the next morning, Sunday morning, and told me that he agreed with me. He agreed with the injunction, and he said he would be calling Mr. May right after he talked to me.
The log and the stump that you and others caused to be placed, was it within the right of way, within the dimensions of Island Street?
Yes.
Not on Mr. May's private property?
No.
This was in June of 2023.
Yes, June 24th.
Did the stump and log, is the stump and the log there today?
No, the Sheriff Lang, before he talked to me, gave Mr. May permission to remove that.
Gotcha. And then Mr. or Deputy Lang changed his view after reading the court order.
Yes,
Did the stump and log get replaced?
they were removed.
But were they subsequently put back?
No,
So I appreciate your clarification on what's strung across the Old May driveway. It's not, I've been referring to it as a chain.
no, it's a cable.
It's a
Steel-
cable.
Steel cable.
Since October of 2022, when this judgment in this case was entered, have you observed times when the cable has been down, if you will, allowing access through
Yes.
the driveway?
Yes,
How many times have you observed
I
that?
probably have seen it at least 5 times down, laying on the ground.
Okay. And to your knowledge, Mr. May is not a full-time resident at his property, is that correct?
That's correct.
Okay. When did the cable replace the log, if you know? Before or after judgment?
That cable was put up after the judgment.
Gotcha.
I believe there was one there prior to the judgment and it was taken down. And then it was replaced after the judgment.
And the cable is attached to the two supporting posts in a manner that it can be taken down and placed back up. It's not a permanently affixed cable that prevents use of the driveway. Is that fair?
That's
In
correct, yeah.
fact, I think you mentioned that it has a lock on it.
There's a lock on one side.
Gotcha. I asked Mr. Weed, Bob, if he had any recollection of a street sign of any kind identifying the location of the new May driveway off the McMaster's Bridge Road. He said he had no recollection. I'm asking you the same question. Do you recall ever seeing a street sign that identifies the new ingress and egress to Mr. May's property?
No, there's no sign whatsoever. No address sign, no name sign or anything.
Is that true to this day?
Yes,
So 13 months after judgment is entered, still no street sign identifying how we get into and out of Mr. May's property?
no,
But there is such a street sign adjacent to Island Street,
yes,
and it remains there to this day, 13 months after the judgment.
yes.
No further questions?
Thank you, Mr. O'Neill.
Please, thank you. I'm trying to get the sequence on. You said that the sheriff's deputies came out June 24th.
Yeah, double check. But yes, June 24th.
So it looks like that was probably a card they provided
Yeah,
to you.
it's got the case number if you want it.
Okay, and that's okay.
Yeah.
At that time, there was a barrier, there was logs or there was a barrier put up. What was
Being what? What are you talking?
he? My understanding is you're saying the sheriff deputy came out that Mr. May complained about you guys blocking the driveway.
Yes,
Okay, so there must have been something was there at that time something blocking the driveway?
that Mr. May had.
No,
there.
no, I'm sorry.
There was nothing, there might have been a log laying on the ground that, on Mr. May's property.
A few moments ago, I thought for council, I thought you testified, you and some others had put
We
some.
Yes,
Okay,
I
and so,
misunderstood.
okay, that's okay.
Yeah.
So what had you put up?
We put a stump,
A stump?
tree stump and a log,
How tree stump, standing up or on its side?
probably standing up.
Okay. How,
Sizable tree stump.
and how long was the log?
The log was maybe 8 foot.
Were both of those capable of blocking the driveway?
Yes,
Okay, now were they located on the street itself or probably up on or more
on the
off of the
edge,
street?
on the edge of the street. on the easement. Though.
And were there?
I didn't hear his last comment. I'm sorry, counsel.
They were located on the street easement or
Okay.
along the side, yes,
Street easement.
not blocking Island Street.
Okay. And that sounds sizable. You and whom put those there?
Myself, Mr. Weed and another neighbor.
Okay, and how much prior to June 24th had you put it there?
Well, 2 days maybe?
2 days.
Yeah.
And you guys are probably stronger than me, but still, it sounds like, did you do it with a bulldozer or a front end loader, or how did you get
We
them
used a
there?
vehicle.
A vehicle?
Mhm.
And then rolled them off of a pickup truck of some sort?
No, we dragged them,
With what type of vehicle?
a vehicle,
Um,
SUV.
Okay, thank you.
Yeah.
Okay, and then, so they were there when the sheriff deputies came out.
Yeah.
You provided them a copy of the court or final judgment at that time.
Mhm.
They left. Was the barrier still up? The log and the stump still there when they
No, they
left?
gave Mr. May permission to remove those.
Okay. So they've been gone from that location since June 24th of 23.
Correct.
Okay,
Or the day after,
Oh.
whenever he removed them.
I'm gonna hold you to it. And since then, have you seen any vehicles go on or off or through that driveway onto Island Street from Mr. May's property?
I have seen tracks,
You've seen, okay, you've seen
vehicle
tracks.
tracks.
And it sounds like you make a point of going to try and see if there's
No.
gonna be anything.
No, it's just, like Bob said, it's when I go out to get the mail, go to the store, go to town.
Tracks, I'm gonna probably slow down and look out my window, aren't I?
I always look,
You always look.
I always look,
You're looking to catch Mr. May go onto that property,
I
aren't
always
you?
look.
Is
Yes.
that what you're trying to do?
You know, I'm a neighbor. I always look out for other neighbors.
Well, you're not looking out for Mr. May. You're looking to catch him going on Island Street, are you not?
That's true.
Okay,
Sure.
and you never did.
I have not physically seen him. No.
Good, okay.
Correct.
And you said that when you put the logs on a little bit before June 24th,
Mhm.
you had not seen him going on that property before you put the logs and stuff on.
No.
Had you?
Other than tracks, yes.
Just these tracks again. Nothing further.
Thank you. Any redirect?
No redirect. Thank you.
Okay, thank you. If you want, you can step down. Any other witnesses?
We rest.
Okay, thank you. Mr. O'Neill?
I sure would like to use the restroom for 5 minutes if that would be
Yeah,
allowed.
Absolutely. Yeah, we've been going.
And then I would anticipate just a short witness of Mr. May.
Okay, so let's take a 10-minute break. We'll come back at 12:40.
Thank you.
Mhm. Okay, we're back on the record. Mr. O'Neill, did you wish to call any witnesses?
Yes, I would like to call Mr. Robert May.
Okay, Your Honor. Mr. May, if you come forward, please, and have you walk right up here to Ms. Nadler.
Can you please raise your right hand? Do you solemnly swear or affirm the testimony about to give today to be the truth, the whole truth, and nothing but the truth?
Say your name for the record, please.
Robert May.
Thank you. Proceed when you're ready, Mr. O'Neill.
Thank you. Bob, can you tell us where you reside?
903 Wadhams Road, Kimball Township, Michigan,
And what county is that?
St. Clair.
St. Clair, okay. And you own, I think we can all surmise you own property up here now.
Yes.
And can you tell us the address of that property?
The address of the property, legal 911 address is 10233 Island Street.
Okay, and is there, when did you purchase that property?
Purchased that property almost 4 years ago.
Can you describe it just quickly as to how many acres or how size?
16,
16 acres.
roughly.
Can you describe the streets that it has boundaries on?
And my property consists of lot A and B. It boundaries McMaster Bridge Road, Island Street, and Henry Street, which is subdivision of Scouts Lodge.
And we were in court here approximately, more than a year ago.
Yes,
And by that, you understand what road are you to use to
McMaster Bridge.
McMaster Bridge Road. And since we were last in court, what road do you use to get onto your property?
McMaster Bridge.
And how do you ever go on to Island Road?
No,
Okay. You've been staying off of that road?
yes.
Okay. And how often are you up here? Like in 2023, how often have you come up?
We were up here just about every weekend.
Okay. What type of buildings do you have on the property?
In construction of a house
Okay. When did you start constructing the home?
last year,
In 22?
22.
Okay. How far along do you think you are?
About 70%.
Good. Do you have electricity at this time?
No, I do not.
Do you have water?
Yes,
You have plumbing?
yes.
And how do you have water and plumbing?
Well, and septic.
Okay. Do you need electricity to complete using those two services?
Yes,
And so you have a home that you're building on it, and who are the builders?
me.
Okay, do you get permits?
Yes,
Okay. And when you must go to the county here in some manner to come and draw permits?
yes, I do.
Okay, and are there people that come out to your property ever to review the permits?
Yes,
Okay, and how do they traverse onto your property?
off McMaster Bridge.
Okay. If I can approach, please. Thank you. You're welcome. If I can start?
Yes.
Bob, what is this?
This is a copy of a attachment I put on every permit. I've reached out from day one of our last judgment and reached out to the ones that were already filed and put this with that. And anything I filed since, I have put a copy of this with, requesting that everybody, including the inspectors, use the driveway off McMaster Bridge.
Okay, okay, and have they been?
As far as
doing
my
that?
knowledge, yes.
Okay, you heard talk about a blue pickup truck, fan of blue, you want a blue pickup truck?
No, sir.
Do you know whose blue pickup truck that
No,
is?
sir.
Did you see that blue pickup truck
No, sir.
in the spot that you were at? Okay, there was also some talk, well, there were some photos from a trail cam of your property and some vehicles purportedly lined up towards that driveway off of Island Road, the 911 driveway, we'll call it.
Okay.
Okay, is there Were there times where you had Jeeps or trailers, et cetera, come onto your
Yes,
property?
campers
How did they get on the property?
off of McMaster Bridge,
How do they get off of the property?
off of McMaster Bridge.
Is there?
Boy, to hear on that point, Your Honor. Did you see, were you there every time you had guests there?
So that
Yes.
sounds like cross-exam to me, counsel. So
Yes, I was.
Let,
Pretty,
but
From-
first, everybody stop, first of all.
Fair enough.
So counsel, if you want to do something,
I quit.
give me a chance to address it before you just start doing it.
That's fair.
And then,
It was going pretty fast.
yeah, so.
But I understand.
That sounds like cross-exam to me. And
Really was.
we're not, there's no exhibits being offered to voir dire or anything. So let's hold off on that. Mr. O'Neill, please continue.
Move for the admission of diagram.
Okay, any objection to that?
No objection. I just wonder what we're gonna call
Defendant 1.
it. Very good.
Thank you, Your Honor. Do you have a circular driveway to go on your property and for vehicles, trailers, et cetera, to go back off of your property through McMaster?
yes,
And how did you make that driveway?
cleared and cut down trees. After the judgment, and I was told that I was no longer using Island Street at all. We, at that point, cleared trees and made a turnaround on my property so we can come in, park by the campers, and drive back out on McMaster.
Okay. Now, we've seen quite a few pictures of so the power company coming to put electricity onto your line.
Yes, sir.
Okay, so I'd like to just cover that. When the pictures were taken on September 26th, it looks like, at least by the trail cam, that's the date. Were you on the property itself?
No,
Okay,
I believe I was at work.
okay, and you, maybe just for the record, where do you work?
Wolverine Packing Company, Detroit, Michigan,
Okay, what do you do for them?
drive truck.
Okay, thank you. And so tell us about the actions you took in order to get electricity onto your property.
I called the power company, requested power from them. They came out, found the closest pole. Reported,
Let me slow you down there. Sorry, you said, when you said they came out, did you meet them at the property when they
No.
came out? Okay, so you called them and told them you wanted electricity.
yes,
What else in that specific first call? Tell us as much as you can about what you said.
I had to go down and file a request for electricity. I had to go down to, obviously, to here and file paperwork for easement rights. For them to do it. They came to the property.
And you weren't there.
I was not there.
Okay, how do you know they came to the property?
They called me and told me that they had decided to go, how to come in and from the property while they were there.
Were they specific as how they said they were gonna come into the property?
Yes, they told me they were, the closest pole was off of Henry Street, behind me.
And how far do you know where that pole is on Henry Street
I think they measured it out as 300 feet
from your property line?
from my build site
From
to
your,
the pole.
okay, so I thought I was stopping you and describing the conversation you had with them. What was the rest of the conversation?
I explained to him that I do not have rights on Henry Street or Island Street. That's why I requested that they came in off of McMaster Bridge. He said that quote, the power company has their own easement rights. If the lines are there, they have easement rights. And that their easement rights, they could use to access the power.
Okay. So that ended that, is that pretty well what ended that conversation?
Yes, it did.
What's the next thing that happened concerning getting electricity here?
They called me and told me that they were stopped and told by residents of the subdivision that there was an injunction against me and they had taken away my rights to get power from there and they left.
Okay, would that have been somewhat subsequent to September 26th that they called that they had
Yeah,
stopped?
I think it was that day or the day after.
Has there been any further activity since then?
No.
Okay, let's go back to when, did you get the idea they came out twice to your property?
Yeah, I know he was there because he plotted it out where he was going to run the power line
Did he leave
prior
it?
to them coming out to do it.
Did he leave any flagging or any indication at all?
Yes.
What did he leave as markers?
Markers were nothing but white flags from my build site to the pole. I didn't use,
Okay, and about how far was the build site to the pole? Did you say?
300 feet,
Okay, was it a straight line?
pretty close to straight.
Did he tell you that he didn't? I think you said in the beginning that you suggested they use McMaster Bridge Road to come into your property.
Yes, that's the way he, as far as I knew, no, that's the way he accessed my property, was off of McMaster.
And after there was, you said there was some white flags put up?
Yes,
Okay. Did you do anything on your property to prepare for the electricity or the power line being
Yes.
put? What did you do?
I cut down 42 trees and pulled stumps and cleared the path for the underground wire from the pole to my build site.
Okay, so was the electricity that was gonna be laid was gonna be underground? Okay, so you set up your, how much prior to them coming back on September 26th had you removed the trees?
It took me a couple of months.
Did you contact them and say, I'm now ready for you to come back? Did anybody ever come and speak to you on behalf of the association
No,
as to what you're doing? Since we were here last in September of 22, have you had any discussions with any of these gentlemen?
no,
I keep calling it like a 9/11 gate to road. Do you understand what I'm talking about?
yes.
What is that?
It was an existing driveway when I bought the property that I started using. It was a convenient, wife said that she wanted her house right there. So it was a very convenient thing at the time.
But off of this court action, you stopped using that?
Yes.
Okay, but was there any particular reason why it had to be kept open?
At this point, it's a 911 access only. And that address is tied to every permit on the build.
Okay.
So until I complete the build, it's kind of hard to move an address.
Once you complete the build, will you be moving your address?
Yes, I will. It will be a McMaster address once the build is complete.
I thought you said you're 70% done.
Yes,
So in addition to, is one of the persons 30% laying the electricity?
yes,
And then you probably have to finish the building itself.
yes, the interior has to be done.
Do you have any other buildings on the property?
No,
Okay. Did you or any of your friends destroy the camera that was across the?
no, I'm not sure what happened to the camera.
Did you know there was a camera there?
Obviously, the neighbors, the other neighbors told me there was one there, but
Did you see it?
yeah, you could see it from my driveway. Okay. If you walked up to the property, it was clear as day.
Your Honor, I don't have any further questions at this time.
Thank you, Mr. Carey.
When did you start the process of removing the 42 trees to establish a line, an area to put the
Exact
line?
day, I'm not sure.
How about a month?
It was right after they contacted me. They came probably a month before they came out. 3 to 4 weeks before they came out, I was there removing them, because then I called them and told them it was done.
Before they came out to put the white flags down, you mean?
No, before they came out to put the line in.
Gotcha. So your testimony is, I think I understand it, but I want to make sure this is what you said, that you asked Great Lakes Energy to bring your electric in from McMaster's Bridge Road. You made that request of them. Is that your testimony?
No, I said that my driveway is off of McMaster Bridge. They can come in that way if they have to. Want to, it's up to them. It's not up to me. You told me how they were coming in. I didn't tell them where to come in.
Okay.
Was
So
it
then
an
I
option? Yes. There's an option in every direction.
All right, so I did misunderstand your testimony through your counsel. You did not say that you asked them to come in.
I asked them to enter from McMaster,
What does that mean?
use the driveway from McMaster Bridge to enter my property.
I got you. And you know now that they didn't, right? I mean, you saw the pictures
Yeah, I see the pictures of them on the easement,
on Island Street.
on Island Street, yes.
Okay. All right, so this sign, it's not unfair to call it a 9/11 sign, and I'll continue to use that characterization. After the court said, Mr. May, you cannot use Island Street, exactly how many times have you gone to the county and asked to have your address changed?
I have not asked for the address change.
So the answer is 0 in 13 months. Is that fair?
Yes,
Okay. And if you know that you cannot be, and your guests, your people related to you by way of business or pleasure can't use Island Street, why then is the chain or the cable, which it's been described both ways, that crosses your old driveway, why is it designed so that it's capable of being taken down and put back up?
I put a padlock on it. It was obviously very hard to twist in a cable and make it permanent. It was already a pre-made cable. I put a padlock on it because that was the only way to secure it, where nobody could just take it off and set it down and put it back up.
And is it your testimony that since October of 2022 that the chain, you're calling it a cable, so I'm going to call it a cable.
It's a cable.
It's cable, that it hasn't been taken down and put back up?
No, it has not been taken down and put back up, as far as I know.
So these gentlemen who say they saw it up and down are mistaken?
Unless I was there working or I was doing something.
Well, if
but
you
I
were
don't
there
remember-
working, why would you
I don't
take the
remember
cable
ever
down?
taking it down. Personally, I do not remember that cable ever being taken down
All right,
since I
why,
put it up.
you heard the testimony of, from Mr. Warner that the police, the sheriff's department paid him a visit.
Yes.
You were here, you heard him testify. It's true that you called them, isn't
Yes,
it?
I did.
And it's true that you called them to complain that someone had blocked your driveway.
No, I called and complained that there was somebody had blocked the 911 address, the 911 access point. If I call an ambulance or I call the fire department, they are going to come down Island Street. They are going to access the property from 10-233.
But isn't that true because you've never once in 13 months asked to change your address? I mean, some of this is your own destiny, right? Some of this you got to do on your own. This exhibit, this defendant's exhibit 1, you drew this, right?
Yes.
Everything on this page is because you put it there. Yes?
Yes,
And you put the address of Island Street on there.
it's on all my bill permits.
Correct? Just
Yes,
stick with it. Yes, you put that on there.
yes.
Where would you expect people to go if you're telling him to go to this address?
To the other driveway that I actually,
So you, even though you put your address at 10233 Island Street, and I plug that into my GPS and it takes me to on a street that you're not supposed to be using, not on you. Right? Not your fault.
I don't give my address to anybody without telling them how to access my property.
You gave a lot of people, it sounds like to me, when you pulled permits, an address from Island Street.
And I also gave them a copy of this. Requesting it coming the other way.
How come you haven't even put up a sign at your new driveway where it meets where it meets McMaster's Bridge Road that says May residence?
It says May residence, my building permit is actually on that front street.
Okay. How come you haven't put up your own sign that invites people to use that driveway? I mean, you see them, right? You see them up and down All the roads in
I
the county.
just haven't had one made. I haven't put
So
one
in
up.
13 months, you haven't done anything to identify that location as how you get in and out of your property.
There's a building permit and no trespassing sign and the build permit for that property.
Beyond the building permit, you haven't done anything. Fair? Is that fair statement?
Yeah.
Okay. Once the sheriff's deputies called you back and said, hey, the stump and the log can be there, why didn't you put them back?
I put up a cable and then that's when the cable went up. I figured that everybody wasn't happy with the way it was blocked with having a log laying there. If we have to put a huge log that in case of an emergency, nobody could ever move.
You pulled a building permit, yes?
I pulled the building permit over 2 years ago.
What other permits have you pulled beyond the building permit?
An electrical and a plumbing.
When did those get pulled?
Actually, I think they were through the summer of this year.
Summer of 23.
Yes.
And for both of those permits, you gave the address of 1023 Island Street, yes?
And a copy of this paper.
Okay.
For both permits.
So the small photographs. You said to your counsel, you testified in response to your counsel's question. Actually, I think it was in response to me when I was out of line asking you the question, that every time you had guests there, you were there.
They might have gotten there before me. Anybody that came up for the weekend, for anybody from the Jeep Club that I belong to, I was, if they were there for the weekend, I was there for the weekend.
Gotcha. But there could have been, sounds like, don't mean to put words in your mouth. There were times maybe when your guests got to your property and you weren't there. Is that possible?
Possibly.
Well, here's the reason I'm asking. Take a look. This has been marked and admitted as plaintiff's exhibit F.
Okay.
Do you recognize what's shown in that picture?
Yes, it's a truck.
Okay. Do you recognize the truck?
Yes.
Whose truck is
My
it?
buddy Christian's.
And Christian, is that what you said? Christian was apparently pulling a trailer with a Jeep on top of it.
Yep, and he parked there.
Okay. And
He pulled up to the gate and parked.
he pulled up to the gate and parked, right?
Yes.
Okay. So if I was Christian and I was ready to leave, and all it was required for me to leave was to take down a cable and shoot out Island Street, it seems like that's what I'd do.
Except that that gate's locked.
Sure, but you're there now, right? You got a key.
And there's another way out for him. All he has to do is.
There's another way out. Well,
Right.
how hard is it for him to back up that truck and trailer and Jeep instead of just going right out Island
All he's
Street?
gonna do
Where,
is
and
back up
isn't,
and go right.
and isn't that why he parked like he did?
No,
Okay.
and he exited out of McMaster.
Because you were there and you saw it. You watched him leave.
Actually, yeah, they all left Sunday morning. I left Sunday afternoon.
Okay. So you were there the weekend that the trail cam stopped working.
I was there that weekend, yes.
Okay. And you knew the trail cam was there.
Yes. When the neighbors had said there was a trail cam out.
Has any official of the county told you that simply because you have a permit pulled identifying Island Street as your address, that you can't change your address until after the permit is signed off? Has anybody told you that?
You cannot change permit address on your well and septic until after bill's complete. Yes, it's right on the paperwork and you fill it out.
What, how, Really, you can't go, who issues the well and septic permit? The health department, right?
Health department.
So you went to the health department, and they
It's right
said
on the permit when you file it.
you can't change your address.
You can, once you file it, or there's no changing the address until after it's attached to the house.
When did you pull the well and septic?
That was back in the first year that I bought the house.
And so before October of 22. Before October of
Yes.
22, right? And you've gone to the health department and said, hey, you know what? I can't use that address. I can't even be on that property. Can we change my address? And they said, no, you can't.
No, when you fill out the permit, it says that you cannot.
The answer to my question, no, I didn't
No,
do
I
any
have
of that.
not doing it and contacted them to see if I can change it.
All right. All right, sir. Thank you. That's it.
Any redirect?
Nothing, Your Honor.
Okay, thank you, Mr. May. You can step down. Any other witnesses, Mr. Owen?
No, we would rest at this time.
Okay, Mr. Carey, any final argument that you'd like to make here today?
May I have a moment? May I ask the last witness one question?
Mr. O'Neill, do you have any objection to that?
Yes.
Okay, yeah, sorry,
All
I
right,
had your shot.
I did. That's fair.
Not to mention, I have another hearing coming up at 1:30.
Which is important as well.
Right.
And you've given us a lot of time, Your Honor. I think the proofs don't just support our request for an injunction, but strongly.
Can I interrupt you real quick? Because I guess I want to know, I know you're asking for injunctive relief, but what are you asking the court specifically to put in that?
One, to enjoin further use of the 911 street sign located at the junction of Island Street and what I've characterized as the Old May driveway. We want that taken down. It is, I was about to swing into argument, but I
And I'll let you do that.
no,
but
I know you will. I know
just
you will.
wanna
And then
know.
second, now that I think I am also asking the court to enjoin Mr. May permanently. And I guess I don't know this, but I'm assuming Mrs. May is of title and their guests, their licensees, their invitees for any reason being on the property of Scott's Lodge subdivision, and in particular, Island Street.
Thank you.
I think we've shown adequate proofs that Mr. May simply did not take your earlier order seriously. He has had over a year to re-identify his driveway, his lawful driveway. He hasn't taken one step to do that. There, circumstantially, certainly, we've had testimony that indicates that the Old May driveway continues to be used. We've had.
Can I ask you a question about that?
Yeah.
Because, I asked the witness about the trail cam and it takes motion activated pictures and specifically these, and it took multiple pictures on this day. If this truck pulled out through there, why would that camera have not caught that?
What
I mean,
time?
to me,
Well, I think I have the answer,
okay,
because we have that truck later in the evening, still in the same position. And then we have the paintball hitting the trail cam. That's why. That's the day it was shot.
okay. So to avoid it taking pictures, how about the other circumstances where, I think Mr. Warner testified that he's seen tire tracks going in and out. Why would that camera have not caught? In my view, it took 29 pictures of the Great Lakes Energy truck there.
Yeah, and
It seems.
my
like-
understanding of trail cams is they are motion activated and there's a setting in them that you can use. They can take picture every 5 seconds, every 10 seconds, every 30 seconds, but I can't answer if the court is really asking if there were tire tracks, how come there isn't a picture that captured the vehicle that made the tire tracks? I can't answer that for you. I can tell you that my trail cams are inherently unreliable and sometimes react to motion and sometimes don't. Sometimes they have dead batteries. Sometimes the batteries are good. I know there's a lot of reasons why I appreciate the point of the court's question, but I also appreciate that I think I have a very credible witness who personally observed the tire tracks. So those tire tracks presumably are at a minimum circumstantial evidence of a vehicle using that drive.
Sure, yeah, I don't disagree with that. I just,
but ultimately,
I just wanted to understand whether there was an explanation other than just luck, that if he happened to be using that driveway, it happened to be at a time that the trail cam didn't take a picture of it or the batteries were.
Yeah, I don't know.
Other than that, there wouldn't be any other explanation for why that cam would never have picked up any cars going in and out.
Yeah, I think there's probably a lot of explanations. I think I'm just not capable of offering them to you, right?
Fair enough, okay. Thank you.
But I think maybe the most damning evidence in terms of Mr. May's mindset here is the engagement of the sheriff's department, claiming that his driveway, remember, this is 8 months after you ordered him to stop using essentially that driveway, because the only way you can use that driveway is by being on Island Street, saying that that's his driveway and he doesn't want it blocked. Okay. And then I think the other damning evidence is I find a hard time believing that someone who is told that they can't use a street makes no effort with anyone, security services, contractors, utility providers, the Crawford County Building Department, to say, this is my new address. Or even try to obtain a new address, even try to put out a simple street sign that says Bob May lives here. Why not do that? He's made no effort to do that. And he's gaming the order, and we don't want that. We want the next time there's a trespass by Mr. May, by his business invitees, by his licensees, we want the security of an injunction. And I can only believe at this point in time, there's going to be another circumstance, at least.
Okay, thank you, Mr. O'Neill.
Thank you. Reason that there isn't pictures of, like you stated, of it going out or going in, didn't happen. There are no tire tracks. I think these gentlemen are not credible witnesses on that. I've never seen people that are more intent on trying to find somebody go on their property, which is good in my instance here, because had he gone on that property, you would have heard about it. They would take every picture, they bring every priest, rabbi, and to come and testify that yes, he was on the property, but he wasn't. There's no doubt. One thing there's no proof that he was ever on Island Street. If you grant an injunction, we're going to be back on something silly like this. What this man was just trying to do was get electricity on his property. There's no damage to any of it. He relies on, I think it's quite clear, he relied on the power company to come. We heard that the damage was going to be the 3 trees. I've been in this area. The court lives up in this area. There's thousands of trees. Weighing 3 trees against somebody for his family and his friends to come on the property. There's that. There doesn't need it. If we give him a permanent injunction, we're going to be back on this case next year when he goes to put electricity again. I'm going to add to it, even with my, I hope, I don't know whether we have to file a motion or not. He still needs to have electricity brought, a power line laid. It's just going to be under the ground. It's going to be the most normal thing to do. I don't know if that would be agreeable to plaintiffs in this instance. I don't see why that's an unreasonable request. But already the court did issue a final judgment back in October. That has not been violated. I didn't hear any violation here. I did hear him rely on the experts to say, will you please lay power? And they came out, and once they heard objections, they stopped it. He hasn't made any other attempts, hasn't done anything to try and get power in some willy-nilly, illegal, legal, any manner until we get to court here. If you look at the final judgment, this court determines that defendant has no legal right to come upon or use the roads as located in Scott's Lodge subdivision. I think that's adequate. I think that's been relied on. A permanent injunction, I don't know what they're going to think up next. And I just think that this has been a sincere waste of the court's time and our time to have to come up on such a small thing as this. Pictures, trail cams, everything they could to show him violating. I think, Your Honor, I think you have to look at it. There's no violation here. There's just a man on one day when he's not there trying to get electricity. That's all. No other days. And it's a red herring about where's your address or where's your not your address. I think he testified as what the permit says. He testifies as to it can't be changed, that he has the intention of changing back to the proper address once all the work's done. But whether there's an address up here or an address up there, he never used that driveway. There's no proof, and he never did use that driveway. He never violated this court's ruling. I would ask you to deny the motion. Thank you.
Thank you, Mr. Carey. It's your motion. I'll give you the last word here.
Thank you. I guess we just look, counsel and I look differently at the proofs that have been presented here today. We would not have filed this lawsuit if we didn't feel, and it's our right to feel, that these are serious trespass issues. Counsel can make them in his mind seem petty, but they're not petty. The proper way to enforce what the court effectively issued as a declaratory ruling, finding a trespass, it's not working. It's clearly not working. Mr. May is clearly not taking it seriously. And I think it's very important, as part of the relief ordered by the court, to order that sign off of Island Street be removed. It's an invitation all by itself. And I think it's equally important that the Old May driveway be closed in a fashion that doesn't allow its convenient use.
So now you're asking for more than what you stated previously in terms of the injunction.
Well, you invited me to offer a closing rebuttal, and yes, I am, based on what counsel has said.
Okay, so in addition to the previous, you're asking the court to order that what
The
occurred?
driveway, or that by some manner that the court finds reasonable, that it is that we fashion relief that prevents permanently access from Island Street to the Old May driveway. And that could include, and we would invite the court to allow us to make that permanent closure within the boundaries of Scott's Island Lodge.
So let me ask you this. I mean, why do you need a court order to do that?
Well, we've had one run in with the sheriff's department to do that. I don't want to. I don't want to fight on at the site when that and if that happens. And I'd like the protection of a court order to do that.
Okay. Reasonable. All right.
Your Honor?
Yes.
Do I know you. Do I need to file our own motion about trying to get an easement to go through just for one day to put electricity on?
I mean, I don't think I can answer that question. That's within your purview, counsel, to decide what you
And the last
need
step
or
about,
don't need to do.
if I, just because it was brought up after I made my closing, as to close it, putting up something permanent. Ambulance, fire departments, I think that has to be taken into consideration. being at the property, that if there is an emergency and the fire department, or somebody has to get in, that's the way they would probably go in.
Because that's where the sign is.
Well, yeah, that's part of, I mean, that's a
But
chicken
next to
and
the
egg
house.
argument there. Okay, give me a minute here, because I do want to rule on this today, so, thank you, but I need some minutes. And if you guys can let the PPO matter know, it's gonna. probably be-
Judge, I have been in contact with Mr. Thompson. He is actually out with the other parts, conversing, so.
Okay. It'll be about 15 minutes. Thank you.
Okay, thanks.
Okay, we're back on the record. I appreciate everyone's patience. I wanted to take my time and go through the exhibits, the testimony, as well as the court's prior judgment. This is, property issues are always difficult. There's a lot of emotion on both sides of it. And rightly so, when you're dealing with issues of trespassing, you feel like somebody is overstepping what they should be doing. It can lead to, it's easy to look at it from an emotional and reactionary way. And I think counsel, I appreciate both of your arguments and positions here on the record. I think you both have done a really good job of making it clear to the court how each of your clients sees what's been going on out there. And that's helpful to the court. So I appreciate the arguments and expressions of counsel. But of course, what we try to do in the law is to take a step back from the emotional part of this and look at it from black and white and what's in writing, what's not in writing, and what does the evidence show has been occurring from an objective point of view, and trying to take those subjective kind of feelings or interpretations of what's been happening out of it. And so, the touchstone here is the court's prior judgment. And what does that judgment say that's applicable to this situation? And it's the paragraph that says that defendant has no legal right to come upon or use the roads that are located in Scott's Lodge. So what does that mean exactly? And one thing that always surprises me, and I'm sure it does to the lawyers as well, is no matter how much lawyers try to put things in writing and the court tries to put things in writing, it's really, really difficult to put language in there that's going to cover every possible situation. And that's why things get so wordy sometimes. And this is one of those circumstances, because what does that actually mean? Defendant has no legal right to come upon or use the roads as located in Scott's Lodge. Who does that exactly apply to? And it's kind of a broad statement. So I think you have to inject some common sense in there to kind of interpret that. And the way that I interpret it is that means the defendant himself, of course, and people that he has under his control, family, friends, guests, people coming up. He should not be using it, and he should make sure that people who he's inviting to come to his property don't use it as well. So what evidence do we have of that? And so I'm creating kind of two categories here. The services like Great Lakes Energy, contractors and those type of people who may be coming to that property when the defendant's not even there. And like I said, family, friends, guests himself who are there at his request and while he's there. So what evidence do we have that he or other people on his behalf have entered that property through Island Road or Island Street? We have testimony that there were tire tracks seen, which is certainly circumstantial evidence that somebody was going back and forth from that driveway onto Island Road. Cable across the driveway being down at some point certainly is some circumstantial evidence that that's occurring. I don't know how strong that evidence is in this case. Certainly the cable could be moved up and down for really any reason, and there's no reason why in the order or any other reason why Mr. May shouldn't be allowed to use his property right up to where it meets the subdivision property. And sometimes there's nothing wrong with him putting that cable up or down and driving through that spot as long as he doesn't go on to Island Road or use the property of the subdivision in any way. He's got a right to use his property the way he wants to use it. And so there could be any number of reasons why the cable may be up or down other than that it's being used to go through to Island Street. The tracks, same kind of thing. I mean, it looks to me from the maps that somebody turning the wrong way, and I'm just looking at Exhibit D here, somebody turning onto Island Street and realizing, okay, I shouldn't be on this road, or I made a wrong turn, could easily pull into that little spot and back out and then go back out to McMaster's Road. So there's all kinds of logical explanations other than that the defendant's driving onto there for the purpose of using it to access his property. That doesn't mean that any of those things are true. My point in mentioning that is it's circumstantial evidence, and I don't think it's really strong circumstantial evidence. There's really no direct evidence that the defendant has used that. And I believe, and Mr. Warner, I think, was very candid in his testimony that, they're watching to see what Mr. May is doing and whether or not he's accessing that property. They've put a camera up so that they can see if he's going onto it. And they're watching it. So I really believe that it's been closely monitored by the residents of the subdivision, and that if Mr. May was using Island Street to access his property, that we would have some photographs or someone to testify, yes, I saw it happening. And we just don't have that. So even under a preponderance standard, the court finds there isn't sufficient evidence to show that Mr. May or any of his guests have violated the order by using that since it was entered last year. I think, certainly the trail camera, I don't know, Mr. May, that it's very suspicious that this camera gets hit by a paintball at the same time that you had guests there. And I don't know if it was you or one of your guests that decided to do that. It's really unlikely, seems unlikely to me that just a random person would see this and shoot this camera. So that's certainly definitely a fishy situation, and one that I think tends to show that, at least on that occasion, perhaps that driveway was used by one of your guests. And maybe not, I don't know, we don't have any direct evidence, but certainly that this camera situation is very suspicious. But be that as it may, the court again finds that there's not sufficient evidence that Mr. May has violated the order by accessing Island Street. But then we have this other category of people, Great Lakes Energy, contractors, and one viewpoint, I think the viewpoint that Mr. O'Neill's expressed that Mr. May takes is, hey, I tell him to use McMaster's, and then it's not up to me after that. They decide what they're going to do. And I don't think that's quite a good enough explanation. And I think the address marker on Island Street is a problem. And I think the fact that Mr. May's address is still registered as being on Island Street is a problem, because no one should be using Island Street to access that property, whether it's somebody that you have direct control of or not. And having that address there is, it's, I don't know if I want to say advertising, as Mr. Carey put it, but or inviting somebody to do that, but it certainly is directing people in some way to that as the way to get onto your property. And you can tell Great Lakes Energy and contractors and all you want to go on McMaster's, but a lot of times they're just going to do what they want to do, and if the address says it's there, then that's where they're going to go. And so I think the address is a problem. But I don't think, I think we need to recognize that the fact that Mr. May hasn't changed the address in and of itself isn't a violation of the order. The order doesn't require him to do that. It doesn't require him to block his that driveway. It doesn't require him to put a cable up or anything else up there. It doesn't require him to, put up a, May's residence sign at the McMaster's driveway. I mean, all of that is evidence, and I get the relevance of it. It's used to make the point that he's not doing anything to dissuade people from using the Island Lake as an access. But the fact is, I mean, he doesn't have to do any of those things. And none of those, his failure to do any of those things is not a violation of the order. And I think to some extent, I think the plaintiffs here they want to feel more secure in him not using, or anyone on his behalf using, Island Street. And they want to see him do things that frankly he just can't make him do. If he doesn't want to put a sign up on McMaster's, he just doesn't have to do that. And sooner or later, I think you guys are going to have to be satisfied with what's happening out there. and not expect Mr. May to do certain things on his property that might make you feel better, but he just doesn't have any legal requirement to do, and if he doesn't want to do it, he just shouldn't have to do it. It's his 16 acres. He can do what he wants on there and put what he wants out, as long as it's not violating the order or going on to Scott's Lodge property. But I get the relevance of it, and I think it does show that it provides more of a basis, I think, for the court to find that the address is a problem and it needs to be changed on the records, and that 911 sign does need to be removed, because I think it's part of the problem that's making this an ongoing thing. Because I think it is directing people to that spot, and I think the plaintiffs have a legitimate concern that as long as that's there, people are going to continue to think that Island Street is the place to go to get to your property, no matter how much you tell other people that they shouldn't do that. So the court is going to order, again, not because it's a violation per se of the judgment, but because I think under the court's equitable powers, it's necessary to fully effectuate the court's judgment. The court is going to order that Mr. May change his address and have that sign, a new green 911 sign issued by the county, and have that posted on McMaster's Road at that entrance within 90 days. I think that's sufficient amount of time. Mr. O'Neill, if there's roadblocks to that, and you can provide documentation of that from the county saying, we need more time to do this, then if it's something that's outside of Mr. May's control and it's a county thing that they can't issue it within that period of time, then let the court know and you can make accommodations for that. But I think 90 days should be a sufficient amount of time to accomplish that. So the court is going to order that take place again within the next 90 days. In terms of the other injunctive relief that's been requested, I think number one, the change of address is going to be a big factor here. I think once that sign is gone, once the address is officially registered as being McMaster's Bridge Road, then I think that in and of itself is going to prevent things like Great Lakes Energy or contractors or other people that may not be directly under Mr. May's control from going down Island Street and thinking that that's the place to access Mr. May's property. Number two, I think in terms of injunctive relief, as I indicated at the beginning of my talk here, it's going to be really hard to draft an order in an injunction that's going to provide the kind of relief that plaintiffs are seeking and not result in unnecessary restriction of Mr. May's right to use his property the way he wants to use it. And I think there are just too many circumstances that are beyond Mr. May's control that could result in, alleged violations of an injunction. Again, just, somebody innocently making a wrong turn down Island Street, pulling into any kind of little opening there on Mr. May's property and turning around. And I think an injunction would just encourage more surveillance, more cameras, more problems than it would solve, in my view. So the court is not going to grant any further injunctive relief beyond ordering that the address be changed and that the 911 sign be corrected to a McMaster's Bridge Road address and placed at that entrance as opposed to on the Island Street entrance. And I want to be clear, I'm not ordering that Mr. May takes that down immediately, because I think I don't want to create a 911 issue between now and when it's moved by the county. So it will stay there until Mr. May completes whatever required documents the county requires to change. So no longer than 90 days though, and it should be gone. The court does not find, I think we had a legitimate dispute on both sides here. So I don't find that Mr. May has I don't think there's sufficient evidence to show that he's engaged in some kind of willful violation of the court's order that would justify the imposition of any kind of attorney fees or costs. In this case, I think there were genuine arguments on both sides of this. And I think, again, that the change of address is going to go a long way towards resolving this. So at this point, the court is not going to award costs or fees to either side or any kind of punitive measures. And Mr. Carey, if you could draft an order that reflects the ruling of the court today, and then submit that either with stipulation as to form or under the 7-day rule.
I'm happy to do that. I do, when the court's ready, have a question regarding the court's ruling.
Sure, yes.
Plaintiffs had requested the protection, I guess, of language in an order allowing them to replace a barricade within the right of way of Island Street. And we want that protection so that the police aren't involved again. The court didn't say that. If the court intentionally didn't say that, then it won't be in the order. But I guess I'm asking if the court had considered that and is saying no to it.
I did consider that as part of the 3 components of the injunctive relief that you were requesting. And at this point, I think, number one, I don't want to order that now because we have that 911 sign there still until the address is changed. And number two, again, I think that change in the address is going to be a big factor in Island Street not being used by anybody as it relates to Mr. May's property. So at this point, I don't think it's appropriate to order that.
All right.
So, I'm going to return the camera. That's noted for the record as exhibit 3, or I'm sorry, exhibit C. And that's the exhibit part of the court file.
Very good.
Thank you.
Thank you,
Your
Judge.
Honor.
Thanks for the time, by the way.